So my name is Megan Leva. I'm the articles editor for WMU-Cooley Law School. The next panelist we have is Beverly Griffor. She's a lawyer, professor, and a mental health professional whose work currently focuses on the application of scientific research in the courtroom and use of expert witnesses. She's the managing partner of Calley and Griffor, PC. She graduated from the University of Michigan and also attended Ave Maria Law School in Ann Arbor. In addition, Beverly subconcentrated in both criminology and social inequality, and she also teaches undergraduate and graduate level courses at Concordia University in Ann Arbor. And she's currently working on a study of child testimony and is pursuing her PhD in clinical psychology with a focus on neuropsychology and forensics. So please welcome Beverly Griffor.
All right, I have to make the technology work now. All right, I'm smart enough to do that today. Thank you so much for the introduction. I greatly appreciate the opportunity to be here and have a chance to speak with you about something that is very close to my heart. I have been working in this area, particularly mental health and social justice in the criminal justice system for about a decade at this point. I'm particularly interested in making sure that all people have access to justice in whatever form it is and whatever location they may be. Let's see here. Oh, there we go. American journalist and satirist H.L. Mencken, who extensively covered the state of Tennessee versus John Thomas Scopes, the Scopes monkey trial, is attributed with the following quote: "Equality before the law is probably forever unattainable. It is a noble ideal, but it can never be realized, for what men value in this world is not rights, but privileges." While he made this statement in relation to the educational system at the time, it is equally applicable to mental health care now. A pattern of privilege means that it's often difficult or effectively cost prohibitive to have mental health professionals involved in litigation in the criminal justice system or anywhere where these rights might touch our courts. So often what that means is the choice to forego those experts and forego their services for our clients is selected. Unfortunately, that means that mental health care often is still considered the privilege of the elite. And in fact, it's really a problem because the very group of people that are most likely in the courts to need mental health professionals involved are also the ones that are not going to get access to them. So in practice, we lose representation for the largest portions of our population. So social justice demands that attorneys and professionals become familiar with how we can use our supporting resources to serve our clients' needs. And sometimes this involves hiring experts, and sometimes this means involving consultants so that we can better understand how we can bring that impact to our cases for a lower cost. But they only gave me 15 minutes. I hear we're playing with that a little fast and loose today, so I'm not going to get a little worried about it. But there's a great deal of information to cover. That's all I have for time. So while there are a lot of aspects of expert work that could be involved, I can't go over everything. So I'm not going to bother you with how to find your experts or how to prep up your cases or what to do in situations when you have active mental health worker involved in the case already. What I'm particularly going to be talking about is how to handle the preparation, the actual engagement. How do you know that you need to have an expert? What do you need to do? And what thought process should you really go through as you embark on this decision? Because choosing not to have an expert oftentimes puts these clients in jail. You are the last stop between your client and the jail system. What you do will often have an impact about whether this person has treatment at all, whether they have effective care, whether they're even diagnosed. The way that the jails and the criminal justice system know that someone even needs care to let the 1.5 therapist get involved with them is if we flag it somewhere. A good way to do that is to get a mental health professional involved, get people involved in the early stages so that the person's needs begin to get met and hopefully treatment plans can be continued. So we're going to talk about identifying an area in need of expert focus in your particular case, constructing an accurate referral question for your professional, and knowing your professional's ethical boundaries. So the first thing we need to know is, how is mental health raised in this particular case? So do you have a family law client who is suffering from PTSD and it's impacting their parenting skills? Are you handling a civil case and somebody was terminated, but there's a question as to whether their termination was because of a factor of a disability that's protected under the ADA? Is your client in a criminal case cognitively impaired so they don't understand the nature of their action? Are they dealing with a comorbid substance abuse disorder that impacted their behavior or their history? Do you have somebody that you're trying to understand whether or not they should be going through inpatient treatment or outpatient treatment? Or is someone on court order and they're trying to evaluate whether or not that should continue? That's how you identify this. Lawyers are pretty good at this. What's the issue? We're issue spotters. That's how we're trained. Unfortunately, we also need to figure out in all these areas whether our client is actually entitled to an expert. And sometimes that doesn't mean entitled by law. Sometimes that means in your county, do they do that? So your county-specific rules are going to be able to tell you whether or not in your situation a judge is likely to appoint an expert in a time of need, or whether there are even going to be funds available, especially towards the ends of the budget year. In some areas, there's case law on point in your particular field. So in the criminal arena, for example, Aki versus Oklahoma tells us that if there is a mental health issue implicated, your defendant is entitled to an expert. Well, we thought that was pretty clear, but apparently not so much. In practice, the expert that they're entitled to is often the prosecutor's expert because they get to talk to them. And in fact, right now, the primary holding in that case is being addressed. So the primary holding is we hold that when the defendant makes this preliminary showing that mental health is going to be at issue, the state must assure the defendant access to a competent psychiatrist who will assist in evaluation, preparation, and presentation of their defense. McWilliams versus Dunn before the Supreme Court right now, argued April 24th out of the 11th Circuit, is addressing this very question. What does it mean in a criminal case that an expert is presenting the defense with support? I don't know the answer to that question. Hopefully sometime in June, the Supreme Court will come back and let us know whether that means we have to settle for the guy that doesn't see the problem, or if we have the opportunity as a right to get funding for some alternative. Now, in family law cases, we have to look at the same questions, but there aren't any rights to experts in family law cases. So if we have children that have special needs or disabilities, or parents that have special needs or disabilities, we are the ones, as attorneys, who are going to be required to show the court that our parent is capable or that these needs are being met. In some cases, that means that we're going to friend of the court. In some cases, that means we're getting independent evaluations or even neuropsychological evaluations of particular parents. And without those, these parents can kiss their rights goodbye, but they're not paid for by the state. In addition, in civil cases, you have a whole set of other requirements. One of the most pertinent is that a lot of those cases have therapists involved already. Someone has gotten involved before the filing of the suit. And you, as the attorney of the case now, have to make the decision whether we're going to get in touch with that person or start all over. This is a case-by-case decision that has to be made. Sometimes we have records to review. Sometimes we don't. We make the best decision that we can. But funding is an issue here too. Because if you try to get a new therapist that will be a little bit more financially friendly for your client, you're going to be accused of trying to stack the deck. Now, in probate cases, we have other issues. Issues in probate cases involve competency and capacity. So in those cases, sometimes we don't even know who the professionals are. So in a probate case, when you're dealing with the administration of, say, a decedent's estate, you don't even know who the decedent's physician was half the time. So now you have to reconstruct the intentions and the understanding of that decedent with the help of a professional, and you have no access to anything. This is not something that most lawyers are very familiar with or have done more than a few times. And if they have, they run screaming as though their house is on fire. The other aspect of this is getting involved in independent medical or psychological investigations for things like guardianships. If you have a guardianship or a conservatorship and you need to be able to make a showing of competency or capacity, there's no funding available for that either. So where that puts us is, what are we going to do about this funding problem? So unfortunately, it comes down to doing our homework. Some counties have specific funds earmarked for some situation that you might find yourself in, although not all. So I check your county, find out whether your particular box is on their little form of money, and then you're good to go for a little while. Unfortunately, each county actually handles these appointments differently. So if they don't have a fund or there is no general fund available for this, then you're looking at sort of standardized payment options. So in Washtenaw County, where I practice, when you are trying to get an independent medical evaluation, say for the purpose of competency, or because somebody is going through involuntary commitment proceedings, Washtenaw County will pay the professional who does that $250. And they wonder why people aren't banging down the door to get involved in this process. Most of these professionals charge more than that at an hourly rate. And guess what? These take about 10 hours to do a pop. They're not fun. They take a long time. It's a lot of paperwork. And we're giving people $250. Now, some counties do operate on an hourly basis. I recently worked on a case in Monroe where our appointed psychologist was paid $55 an hour for a maximum of 12 hours. Kind of arbitrary, but that's the way it works. And then I've also worked in other counties and done consulting in other counties where the hourly payments are between $75 and $150 an hour. So what we're saying is, in cases where people need the help and they run into the criminal justice system, or you're threatening to take away their children, or you're saying that they're incompetent and can't manage their own affairs, and they don't have the funds to fight you, who's going to help them? So what other resources does your client have? Do they have any special memberships? Do they have anything at all that you can draw on? Do they have access to Veterans Affairs services? Are they VA veterans? Do they have AARP services? AARP actually has some pretty interesting discounts for their members as far as member services. Do they actually qualify for Medicaid or Medicare? Because of course you can get evaluations through both of those programs, although waiting lists can be challenging, but judges usually understand. Do they have any other membership that they pay for? So do they have a disability or an insurance policy that could be drawn on for these funds? If they don't have those, we look at whether there are nonprofits that are available that can support them. And in many cases, this does exist, particularly with those with disability or those who we believe have, we want to screen, say for intellectual disability or developmental challenges. Now, the other issue we look at is whether they're already existing reports. Do you already have therapy notes? Did this person come to you having already been in 2 years of therapy with a diagnosis of paranoid schizophrenia before they came to you? First, you probably don't know what that means. Read the reports. Figure it out. You need an expert. Do you have school records? Do you have occupational therapy records? Do you have anything from the developmental history of this individual, particularly when you're dealing with young adults? This information might still be accessible. High schools may have it. Grade schools may have it. Do you have IEPs that you can look at? Anything that you can look at helps you here. Because if you have the records, your first step might not be an expert. Your first step might be a consultant. Somebody that can sit down with you and say, okay, let's figure out what direction you need to go to address this particular individual's needs. And the good news here is that consultant signs their retainer agreement with you. That means all of the communications between you and the consultant are work product. You don't have to turn over any of that at any time. Now, that consultant isn't testifying. So when you choose to use a consultant, you have to be fairly certain that you either can afford or absolutely cannot afford to have an independent expert work for you. So once you've gone through that whole process and you know that you have a client that has some sort of mental health challenge that they're facing and they've gotten themselves somehow involved in the criminal justice system, you've figured out what the issue is, essentially, and you've identified sort of the funding source, you now know how much or how little you have to work with. What that means is we have to get good at constructing a referral question. We have to be able to articulate what it is that we want to have assessed. I am both an attorney and a mental health professional, and the number of times I have to call an attorney and say, this is not a thing, is amazing. We, as mental health professionals, need to know what you are asking of us. And so this is what I ask people to go through, and I want you to be able to understand that. First, what is the ultimate question? What is the outcome that you are seeking? What do you want to have happen? Does the ultimate question here involve state of mind? Are you trying to show capacity or lack thereof? Are you trying to prove parental fitness? The first thing you need to know is really what that end goal is. And again, attorneys, we're issue spotters. This you should be able to do, and it's the way you start. Next is sort of that underlying question. Okay, well, what do you really need to know? So what are you missing? What would you have to show in addition to the information you have in order to answer the question? So what piece is missing? Do you need to know what somebody was thinking at the time of a crime? And if you knew that, you would have the answer. Do you need to know how somebody's decision-making process works to know whether it's sound? Do you have to be able to prove that granddad knows what property he owns? Do you need to know how to identify if someone is operating under a delusion? Do you need to know that somebody can understand what their child's interests are? These are all questions that aren't really the ultimate goal, but they're that piece that's missing for us. Very rarely are you going to be dealing with a professional where the ultimate goal and that piece are exactly the same. Next, you need to know who do you need to prove it to? And in addition to that, what context are you in? So judges and juries take in information differently. And the context here is important as well. Motion hearings versus bench trials versus jury trials. The setting is key because you can attach things to motions that you can't attach to juries. You can present things in different ways to each of these bodies. And what that means is what you're looking for and how you're going to present that is going to be different. And your presentation to the fact finder may impact what decisions you make about your expert. So your audience and your context matter here. Then you want to know who can help you do that. You know what to prove, you know who it needs to be proven to, but who is going to be the best person to explain that? If it's the neighbor, then you don't need an expert. If it's the neighbor who says, oh, I saw him outside right before he got into that fight, chasing a demon through the sky, yelling at it. Okay, probably at this point, you can explain that to a judge. Probably at this point, you have enough to sustain sort of maybe the burden for a motion, right? You don't need an expert to meet that kind of a threshold in that situation. But in a jury trial, jury doesn't really get anything else. They're not going to be able to take that presentation and draw conclusions from it. And that's what your expert would be for. So you need to identify who can help your fact finder draw conclusions if they're necessary, and then figure out how what they would say could impact your case. And that's the basis for the beginning of that construction. Then here's the punchline. What specific question do you want your expert to answer? What specific question? So you can't just give the entire file to the expert and say, go. That's kind of like driving your car into the dealership and being like, I need a service appointment, something's wrong, and then running away. All right. They're going to ask you questions. When was it last working? Do you have the service history? Do you have any other paperwork? Have you ever had a problem before? And where is the noise coming from? Right? That's what you're doing with this question. Because a mental health professional approaches a case differently depending on what the question is. So if you are asking, does this particular defendant understand right now what's going on? That's all that the mental health professional needs to evaluate. They're not going to read all of the history of the case, right? They're going to need to know some psychiatric history. They're going to have background information. But you save time by giving an accurate referral question. And time is money. And money is what prohibits many, many people from getting access to services. So if you can squash the timeline so that your indigent client is not paying $75 an hour for your expert and you, now they're going to have access to some care. Next, you need to know your professional's ethical boundaries, and I cannot overstate this more. Know the boundaries. Once you have the resources that your client has and you've put your referral question together, you're at a point now where you're deciding what kind of professional you need to deal with your client's needs. Are we dealing with multiple sclerosis? We need the doctor, a neurologist. Do we need a clinical psychologist to talk about things like cognitive decline in major depressive disorder? Do you need a forensic psychologist in order to demonstrate a review of a pattern of history over an extended period of time? Do you need the person's personal therapist to describe their experience of an event? Do you need a psychiatrist to talk about medications and how they might be influencing your particular client or your client's situation, right? Once you've figured that out, take a look. Take a look. Take a look. All of these individuals have governing bodies. Those governing bodies have rules about what those professionals can and cannot do, much like the rules that bind attorneys. So you have the American Medical Association, the American Psychiatric Association, the American Psychological Association, and those are just the ones that start with A. All right. All of these professionals have those. Before you call your professional, pull up the professional rules for the field that you are looking to engage and make sure what you want to ask them is proper. For example, it is not ethical for a psychologist to diagnose your client's ex-wife with bipolar. You can't do that. You can't ask your expert to do that. because they're only permitted to diagnose people who they have done in-person evaluations with. So you cannot demonstrate that your client's ex-wife is bipolar and therefore should not have the children or any of your money by giving a stack of papers to an expert. That's unethical for them. It's not unethical for you. You can give them and ask whatever you want, but it's going to cost the money to write the report that says, I'm sorry, we can't do this, and here's why. Because they're going to write you a 3-page CYA letter, just like you do when people ask you the same question, and they're going to bill for it, and then you got to start all over again. And now your client's running out of money. Right? So don't ask that question. A psychiatrist can't testify as to how a particular drug gave side effects to your particular client at any particular time. What they can say, if they have enough information, is how this individual generally reacts to this medication. And if they haven't met your client, they can't even say that. They can say that Ritalin has side effects that cause insomnia in some people. No idea if that in fact impacts your guy. So don't ask a question that they're not going to be able to answer. And if you do, they're just going to tell you, I can't do that, and you're going to have to start over. But if you then have that person testify for you, they now get to field that question. What were you asked to do? Well, the first time I was asked to do this thing that I can't do. And then the second time I was asked to do this thing that I can't do. And then the third time, this is what I asked, and I did that. Well, now through no fault of the paperwork and no fault of the professional, they're not looking like they're really impartial. So we have to be careful about that. The other issue is that we don't put our expert in jeopardy. We're professionals. We work together. It's the only way that any of this makes any sense. We have people in a very vulnerable group that needs support. And the only way that we can do this is if we all work together. And in order to do that, we cannot put each other on the hot seat. We just can't do it. So if we give that information out there, we could serve to discredit our expert. And in some cases, we could even disqualify our expert. Maybe we gave them something right away that they shouldn't have according to their professional ethics. Maybe they used to work for somebody that's related on the other side, and we didn't look into that. And it's a conflict for them because they're still in touch or have access to information. Now, not only are we putting our expert, our professional, in the hot seat, but we're jeopardizing our own case. So we want to be careful when we're interacting, particularly in the initial engagement with an expert, that we're doing the best we can to make sure we're following their ethical boundaries. So, this is the we're almost done slide. Yeah. So we want to identify the area. We need expert focus, know our client's rights, identify the funding source, know our limits, know when our client has to cut and run, and do everything that you can within that bound. Construct an accurate referral question, identifying the issue, what do you need to prove and to who, and what specific question needs to be answered. And then select your field based on the information you have, review those ethics, and make sure your requests are appropriate. Now, I can't tell you everything there is to tell you, and I did the best I could, but even I had to cut some stuff out, and I'm still over time. I sucked my extra time out, just like all my colleagues. Maybe the guys later will do a little bit better, who knows. But if this doesn't answer questions or you need a little bit more, find an expert and take them to lunch. We eat, we talk, we love our jobs. We want to tell you all about them. We want to tell you what ridiculous things so-and-so did. We want to tell you what we wish people would give us more. We want that. Please, goodness, find someone who's in your area that you work with or that you want to work with. Feed them and pick their brain. It's an excellent, excellent resource. Next, join an organization. Whether it's a professional organization or an informal group of some kind, join them. Sometimes there's special prices for affiliates, meaning I'm not a doctor, but I want to know doctor stuff. Sometimes they're cheaper prices for those. Sometimes you can get on listservs where like smart people tip questions off of each other, and you can be one of those smart people and help each other out. Listservs are fantastic ways to brainstorm, and they're fantastic ways to get additional information. And then finally, read. As attorneys, that's what our bread and butter is. We read, we argue. Read cases. Read the cases that involve experts, even if those experts aren't mental health experts, because how you deal with your expert is going to be very similar to that, but have a special bend to it because of the mental health need. Really, what it comes down to is, as attorneys, it's our job to be the last line of defense. If somebody has gotten to us and they're unserved, we need to do something about it if we can, and we need to protect their rights, and they have a right to their own health. They have a right to that. All right, I'm not going to talk about whether we have a right to health care or not, but we have a right to try to be healthy. All right? We don't want to penalize people for things that are not their fault. And for the most part, the people that are finding us, particularly people that have not been diagnosed, people that have not gotten into the system, because maybe they're really good at living with their disorders. All right, when you catch those people, do everything that you can within their means to direct them the right way. Thank you so much for having me.
Hello, I'm Andrew Hendra, and I'm the editor-in-chief of WMU-Cooley Law Review. The next panelist we have is Milton Mack, Jr., who was appointed state court administrator in 2015. Judge Mack previously served as Wayne County probate judge from 1990 to 2015, in which he was chief judge from 1998 to 2015, and served as Wayne County commissioner from 1983 to 1990. Currently, Judge Mack serves as a member of Governor Snyder's Mental Health Division Council. He also served on Governor Granholm's Michigan Mental Health Commission, Judicial Crossroads Task Force, and 21st Century Task Force of the State Bar of Michigan, the Judicial Needs Assessment Committee of the Michigan Supreme Court, the Michigan Partners in Crisis Public Policy Committee, and the Michigan Supreme Court Guardianship Task Force. In 2014, Judge Mack received the Mental Health Champion Award from the National Alliance on Mental Illness. He also received the Frank J. Calley Public Service Award, the Treat Award for Excellence, the Tom Bradley Leadership Award, and was named one of the 25 leaders in law by Michigan Lawyers Weekly.